DeVito. I'm Amanda Carl, as you know. I'm the vice chair of the 50 JNC. You've been here in front of us a couple times now, so you know the drill. We'll all go around and introduce ourselves and tell you where we're from, and then you'll have 2 minutes if you wish to make any opening remarks. We'll follow that with questions, and then we'll reserve some time at the end if you want to make any closing remarks. Also, it just, as you've probably seen when you came in, we have a video camera today. Volusia Exposed is here videoing, so sit straight. And we'll go ahead and start with you, Craig.
Craig Dyer, Public Defender's Office, Daytona Beach.
Good morning, I'm Amy Patriot, Brownlee Law Firm.
Brett Renton, Stratton, Bowman, Orlando, Florida.
Good morning, Andy Bardos and Gray Robinson.
Good morning, Vince Citro with the law offices of Horowitz and Citro.
I'm David DeArmas, I'm Kramer Price and DeArmas in Orlando.
Well, first of all, I want to thank you for your service. This is the holiday season, and I know this is probably requiring you to take time away from your families, and so I appreciate your service to the citizenry of Florida and to the bar. Like you said, I've met some of you before because I've been through this process a couple of times, and some of you I'm meeting for the first time. I've been a lawyer for 23 years. I'm an appellate lawyer. I do quite a bit of trial support. Do legal research and writing analysis, writing motions for summary judgment, responding to those. I think of my career as being divided into 2 major parts. First part, I was a commercial litigator and media law attorney, and for the past 12 years, I've essentially done appellate law as a solo practitioner, and like I said, trial support services. I graduated from Louisiana State University. I was in the top 10% of my class, did law review. And I had the privilege of serving as a judicial clerk to a United States District Court judge in the Middle District of Louisiana following law school, and that was a tremendous experience. And I think my work as an appellate lawyer has enabled me to develop the skill set that appellate judges need to do well on the appellate bench in terms of writing, like I said, analyzing legal issues. So with that, I'll be happy to answer any questions.
Ms. Kozan, I vetted your application and spoke with a number of people about you, and all of their comments were very positive. The refrains that I heard were intellect, writing ability, and a calm demeanor. I probably heard calm 6 or 7 times. So could you address that and kind of speak to what your demeanor would be on the bench and why you think that's something that I've been hearing so frequently in talking to people about you?
I'm glad that I project that. I don't necessarily always feel calm, especially right now. But I think judges should be quick to listen and slow to speak, and I think that's my natural personality trait. And I think, especially in the appellate judging realm, collaboration is very important. And I think getting the right decision is very important, and that's best done in collaboration. And I think when you can hear other people's points of view and convey that you've actually understood that, then that helps you towards getting the right answer. And like I said, I think that's my natural personality trait.
The other thing that I heard, apart from the fact that you're an excellent tennis player, is the intellect and the writing ability. So tell me, when you get an appeal and you're looking at the issue for the first time, kind of what is the process by which you go about analyzing the issues, researching, writing, thinking through the issues, working with co-counsel to get to the arguments that you want to make and really developing the arguments? How do you go about that process?
Good trial counsel can be very, very helpful, but I've also learned that you can't rely on how trial counsel represents the record will be. So I think reviewing the record, a cold record, analyzing the issues independently, and I think sometimes getting separation because you're looking at anew helps, because you can put yourself more in the frame of mind as a judge looking at a cold record would. And then attacking research, doing independent research. I never rely just on what a trial lawyer has done, although like I said, if they've done a good job, it makes my job a lot easier. It's a good springboard starting point. And there's not always an answer in the case law, as you know, a clear answer. So arguing analogous issues is helpful. That's how I approach it.
And the other thing, just, this might be my last question, the other thing I noticed in your application where, which was the only thing that gave me a little pause, is that you spent some time here, some time there, 2 years, 3 years, 4 years, and then you've done some contract work since then. And now you've had your firm for a number of years. But this is, for you, perhaps a 20, 25-year commitment. So is this something that you see yourself seeing through to, for 20 plus years, working hard as a DCA judge? I think the answer is yes, because everyone says you really have a love for appellate practice and for issues and analyzing issues. But is this something that, and obviously, life happens, and so ironclad commitments are, I'm not asking for that, but do you see yourself doing this for a long period of time and working hard day in, day out?
Absolutely. I'm a very hard worker, and this is the job that I really want and that I think I'm well suited for. It's not a stepping stone for me. Ever since I clerked for Judge Polozola, I thought that one day I might like to be a member of the judiciary, and as I've developed my skills as an appellate practitioner, I think that's where I would fit best. I think I have the right balance of the years of experience under my belt, but also being young enough to serve on the bench for a number of years. And I listed all of those firms in my application because that's what the application asks for, every firm I've been affiliated with. So if I, as a contract attorney, appeared as of counsel or my name went under another firm, I listed that out of an abundance of caution in the interest of disclosure. But I've essentially been a contract attorney and solo practitioner for 12 years. So yes, I've been affiliated with a number of different firms, but I think that speaks to the diversity of my experience.
Great, thank you very much.
Good morning. So the questions I've got for you, should we require that all of the names that we send out have prior judicial experience?
Well, obviously, I don't think so.
Why?
You've put practitioners through before who are excelling on the 50 CA. Judge Edwards would be one example, or some who have had limited judicial experience. I think that the experience of analyzing legal issues, reviewing issues on a cold record is more appropriate for an appellate judge than trial court experience. I think good trial court judges, that requires a lot of skill, but it's a different skill set. And I think you have to look at the individual, and some individuals have both skill sets, but not everybody does.
What do you think is the biggest challenge to the courts currently and their ability to maintain their integrity or independence?
I think funding is a big issue. It's a separate but equal branch of government, and I don't think it's funded equally. And so I think that it's difficult, and usually when individuals go to the court, it's because of something very personal to them. And if justice delayed is justice denied, and if there aren't the number of judges and good support staff there, then it's difficult to put out timely decisions. And so I think that's the biggest threat. I think separation of powers is crucial to our form of government and protection of liberty, all of our liberty. And so I think that requires that all of branches of government be separate and equal.
Thank you. And the final question I've got is, I believe the last two application rounds, I'll call it, I think you were shortlisted the first time, and then this last time you were not. What have you done since that last list was sent up in your practice? Have you made any changes? Have you done anything different in terms of what you're doing?
Well, I've been very blessed that I've had a very busy appellate practice load of late, and so I think I've been improving my skill set in that regard. I've remained active in the appellate practice committee, and I've remained as a member of the Ninth Circuit grievance committee. So I think all of those have made me even better prepared to serve.
I mean, you touched on the separation of powers, and since you aren't a sitting judge, it's sort of hard for us to glean what your judicial philosophy might be. And so I'm wondering if you can talk a little bit about what sort of judicial philosophy you think you would bring to the bench.
Okay. Again, I think separation of powers is very important, and the role of the judiciary is a limited one. And I think a judge should apply the law as it is written, and as it is fairly interpreted, and not to make law. And I think constructions of statute shouldn't be broad or narrow, but should be fair and reasonable, and should include everything that a statute fairly encompasses.
Can you think of a recent decision from the Fifth that either did a good job in applying a statute or a bad job?
Good job
Why?
of applying a statute or a bad job.
Meaning you either agreed that they fairly and plainly read the statute as you think it should be read, or whether they sort of botched it and misinterpreted a word, maybe didn't give the word, we've heard originalism a lot today, so maybe they didn't give the word its original meaning that it had when it was written, anything like that, any sort of analysis.
Well, it's not a statutory decision, but one that comes to mind is the Worley versus YMCA case. I think it was from 2015, I believe Judge Lambert wrote it. And the issue in that case was whether a defendant in a personal injury action is entitled to discover the referral relationship between a personal injury plaintiff and the law firm of the personal injury plaintiff. And so it interpreted basically the attorney-client privilege. And I think the Fifth District got it right and said that that was not protected by the attorney-client privilege, because a treating physician is a hybrid expert, but is an expert nonetheless, so the jury is entitled to know if there's a bias there. And so I thought that was a very well-reasoned decision. Unfortunately, it was reversed by the Florida Supreme Court, but I agreed with the dissent in the Florida Supreme Court case. So that's not a statutory interpretation, but it is one that comes to mind that I agree with.
Thank you.
Dealing a lot with appellate work, you, I would assume sometime in your career have come across a PCA against you. What is your opinion of that, of your PCAs? Have you ever felt they're absolutely incorrect and somebody should have wrote an opinion?
I have. I think all appellate practitioners have experienced that. Sometimes it's hard to glean why, because obviously as an appellate or someone who represents an appellate, I believe that I have an appealable legitimate issue. I've heard feedback from the courts that if it's an area of the law that's already well established, it doesn't help to add to the decisional law. I might change my perspective once I get there, but I understand that perspective. Sometimes they say perhaps an issue hasn't been preserved, and they don't want to call an attorney out on that, publicly. But sometimes, yes, it's just a puzzle as to why there's a PCA.
Would you take that to the Fifth District Court of Appeals if you were appointed to the position where you would more closely scrutinize your other judges wishing to have a PCA?
Yes, and I think that's a benefit of being a practitioner, because I understand what it's like to be in the shoes of a practitioner. I'm close to it. And I think even a citation opinion helps, because it gives guidance as to what the court's thinking.
So you touched upon the diversity of your practice and what you've done since the last time you were before the commission, and how you've addressed some of the issues that you think make you a better candidate this time around. It appears to me statistically close to 80% of what the Fifth DCA hears are criminal cases, but I don't see any criminal experience in your application. Do you see that as a weakness in your application? If so, what is it you would do to overcome that? And if not, why not?
Okay, I don't see it as a weakness. I have done a very small amount of criminal law. It is a big part of the docket on the Fifth District Court of Appeal, but my understanding is that area of the law is fairly well settled, and while the court does get issues of first impression on occasion, it's not often, and a lot of the cases are repeat issues. So
Any other questions?
Post-conviction motions, I guess, I'm sorry.
Yep.
I couldn't think post-conviction motions, but it came to me now, sorry. A lot of them are post-conviction motions and appeals that are from.
Thank you. Well, if you would like to make some closing remarks and let us know anything else that you would like for us to know in making our decision.
Well, once again, I thank you for your time and for your service. I think the issues of separation of powers are bigger than any one person or court or case. And I, as a human being and a compassionate person, I understand it will be difficult sometimes to rule, but there's not always a remedy in the court. And I think I can be allegiant to those higher principles of separation of powers and the limited role of the judiciary. And like I said, this is a job that I see myself doing, if I were so fortunate to be nominated or appointed, for a very long time.
Thank you so much.
Thanks for
Thank you.
Thank you.
Thank you.
Happy New Year.
Happy New Year.
Thank you. And David, we have a break now, so.
Take a break?
Yep, we've got a break.